I'm an attorney with the Strategic Legal Group. I'm the managing attorney there. Of course, when you talk to an attorney, you're not going to get away without getting a disclaimer, and this is my disclaimer here. We're in a big group, so there's no attorney-client privilege, so any questions or anything you ask, guess what? Everybody gets to hear here and on the web, because we're taping this. Also, the information I'm going to go over today is very kind of a high-level information. One of the things I love about what I do is everybody's family dynamic and everything's a little bit different. So, you know, the facts that I give today are just like high-level facts. They may not pertain to exactly your situation. So I would recommend that if you, you know, are looking to do something in particular, that you see an elder law attorney who specializes in those kinds of things to help you out. One of the big things and major concerns that a lot of people have in the elder law community that I serve is long-term care and how will they need it, you know, and the statistics show that over 70% of people 65 and over at one time in their life will have to do some long-term care. As you all know, and I'll go over a little bit later on, is, you know, how do you pay for it? This stuff is not cheap. Also, how will be having to need this care? How can it affect my family? And how do I keep my dignity during this whole process? Which to me is the most important thing of all. My mother suffered from Alzheimer's and dementia. And so my biggest thing when having her taken care of was that her wishes were followed and that she kept that dignity through that whole process. And then, you know, the big thing is having your plan in place to have the people that you want to help you with those wishes. You know, I talked a little bit about numbers, and I'm going to go over a little bit on that for you. But you can take a look at this little map here, and it shows you in the next 10 years, the growing population in California that are going to be age 60 and older is going to increase. And all of the little red counties that you see there, it's going to grow over 100%, I believe. 200%, yeah. Isn't it great? Yeah. Because none of us are getting any younger. I tried that this morning and it didn't look right. So, and then as you can see throughout California, you know, our whole population with the baby boomers and everything growing is just getting older, and we are, you know, our population is getting bigger because I throw myself into that now. There's an increased need for care. And there's different types of care that's coming in. And according to the U.S. Department of Health and Systems, someone 65 today, like I said, has a 70% chance of needing some sort of long-term care, whether it's in a skilled nursing facility or whether it be home health. And I have a lot of stuff to go through, so that's why I'm kind of going a little bit quick. But the big thing is how you're going to pay for these things. As you can see, it's a pretty expensive proposition getting old. Adult daycare can cost you up to $75 or $77 a day. That's $30,000 a year for somebody to you know, just go to adult daycare for 8 hours a day. Home health aid, I have in there home health aid coverage. I have that in there just at 16 hours. For a day at an average of $23 an hour is about the cost of that now. That's $11,000 a month, which is pretty pricey, or $132,000 a year. And assisted living and skilled nursing facilities, you're talking about $10,000 plus a month for that, or about $127,000 a year. And that's just you know, for living expenses. So a lot of people ask me, you know, how do you pay for long-term care? And Medicare will help you with that if you get hurt. The thing with Medicare is that for it to cover skilled nursing and rehabilitation, you have to spend at least 3 days admitted into an acute care facility or a hospital. And that sounds pretty straightforward or simple. but it also, oftentimes is not. You fall, break a hip, go into the hospital. A lot of times you're in the ER, an emergency area, for, hours, if not almost a whole day. You get admitted, they take you, get taken care of, and you think you've been there for 3 days, but you don't really get admitted until they actually bring you out of the ER into the hospital. So I've had a lot of clients of mine that I've had to fight with Medicare over when the exact time and date of the admission was, so that they could get covered for the rehabilitation. If you're in there, it's one of the things you really have to talk about, because hospitals are, like everything else, busy and impacted. They want people in and out and get them into the rehab facility. So you want to make sure that you have the requisite amount of time to be able to get in there. Medicare will pay up to 100 days. The first 20 days they pay 100%, which is great. And then days 21 to 100, there's a copay. It just increased this year. It's now, the copay is $170.50, I believe. Yeah. That a lot of times, if you have a supplement, will be covered. So that's helpful there. The problem is, what you get to is if you have to be there, over that 100-day period, what do you do? Now, to be eligible for this care, you have to be deficient in at least what they call 3 of the activities of daily living. We go by the acronym when we use this as BADIT. So you need to be unable to bathe yourself, ambulatory or move around, transfer from bed to wheelchair, or bed to out of bed, toileting, eating, and dressing. Those things there, if you're deficient in at least 3 of those areas, then you qualify to go into the skilled nursing facility for rehabilitation. And they work on trying to get you taken care of and back into shape so that you can do those things and return home. If for some reason you can't, though, then you're looking to extend your stay there. And after the 100-day period, you need to find out how you're going to pay for those things. As I said, it's pretty expensive. We saw in the previous slides. There's a couple ways you can go. You can pay cash using your assets, or you can try to apply for assistance. How do you qualify for that assistance? Well, some people have some long-term care policies I've seen out there. They're actually very few and far between. The insurance companies offered them quite a few years ago. Then when people started using them, they figured it wasn't a great deal to sell. So they stopped selling them for a while. They're getting back into selling them, but they've learned to cap their limits and stuff. But if you have one of those policies, it's a great thing to use. The other thing is to see if you can qualify for benefits. And one of the main things that people use to qualify for benefits is Medi-Cal. Medi-Cal will pay for long-term care for you, and it's a great program. If you qualify for assistance with Medi-Cal, your quality of care can't change. So if you were paying cash for your nursing home care and you went on Medi-Cal, under California law, nothing can change. They can't move your rooms, they can't treat you differently, they can't do any of those things, so that's really nice. But to qualify, the nursing home's going to tell you one of 2 things. If you're married, they're going to tell you have to get your assets down to about $126,000. If you're single, they're going to tell you have to get your assets down to a whopping $2,000. That $2,000 limit has not changed since the start of the Medi-Cal program. We've tried to talk to them to increase it, but to no avail. But is there a way, so most of the time these facilities are unaware of different things you can do, so they'll just basically tell you, well, you have to spend down all your money. Once all your money's gone, then we'll get you assistance. But there is a way around that. One of the ways is to do some pre-planning stuff, and one of the main pre-planning guides that you can do is have a good trust together, and I'll talk to you about that. And with that trust, also is to have a strong power of attorney. And then, of course, you want to have all your healthcare documents and stuff in order just for you. If you don't have that stuff in place, there are other ways to assist you as well. I do a lot of this. It's called crisis planning. And it's a little bit more difficult, and it requires some action from the courts. But I often go to court to talk to them, the judge, and explain the situation, get conservatorships, and be able to put stuff away in the trust to protect some of them. So how can the trust help you with some planning? So I got an example here. Say you had a home, modest home, $350,000. You had a couple $100,000 in your 401k. You have a cash assets of about $100,000. So you're talking you have about $650,000 in assets. Like I said, the nursing home's going to tell you to spend all of these assets down to the required minimum. If you're married, it's $126,420. If you're single, it's at $2,000. The solution to that is what we call a Medi-Cal Asset Protection Trust. And the way this trust works is I liken it to a secure lockbox. And what we do is we take the extra assets that you have, whether it's your home, cash, or your retirement benefits, and we move it from your name into this special trust. And the way this special trust works is the special trust is an entity basically separate from you, almost like your own separate corporation that you set up, okay? And those assets are in that trust and don't get counted against you for Medi-Cal qualification. So you move those assets over there, that money can be set aside in this box for you, and then what happens is when you need money for things that's not covered under Medi-Cal, then that money, your own money, can be used to supplement your benefits. So, for example, my mom, she was in the nursing home. The diapers that she had, they gave her, caused her to have urinary tract infections all the time. So we were able to use the money from this trust to buy her the better diapers that didn't cause this all the time for her. And the great thing for her, and I felt for me and my family, is that she was able to keep her dignity because it wasn't us supporting her. She was able to use her own money to take care of her own needs. The other issue, though, is if you get on Medi-Cal is what about the income? And this can be a big problem for a lot of families. For example, I went into the nursing home, and they would take a portion of my income and my family income to pay for that, and that's what's called the share of cost, okay? That share of cost can be pretty significant. For example, I think I have it in this one. Say Dad here has a pension of $2,300. He gets Social Security income of $1,200, and then he has to do his RMDs from his IRA, so he gets another $800 average a month. And say Mom gets $1,000. So the total income for the family is $5,300. If Dad had to go into a nursing home facility, Mom would only be able to keep $3,161 under the new numbers of that income. And the rest would have to go to the nursing home facility for share of costs. That can be pretty hard and devastating for a lot of families here, especially in California, where the cost of living is, pretty high, and more people as they get older don't have their homes paid off, they need that money, you know, to maybe even make the mortgage, or even maybe mom's at home and needs in-home care, and that's expensive as well. So she may need more than that money. So what's a family to do on that? Well, what we do is we're able to go to court, and we are able to talk to the judge and get an order and show the judge that there's a need for that additional income. And we're able to get that income increased. Oh, I can get up here. Maybe I'll just use this. Oh, we're able to get that income increase for the family so that we can help them with so mom can keep that extra money to pay for those other things that she needs. There's two ways that we do that. Normally, like I said, the main way that we do it is go to court. You can also try to go to the Social Security Administration or DCHS and ask them for it. But we find that the local courts are the best way to go because the judges there are more sympathetic, you know, to these kinds of needs. No judge wants to be the one that's known as the judge in the community who denied, you know, grandma the ability to stay in her home, right? So we use that all of the time to be able to increase that. So we're able to get them into a skilled nursing facility, get that paid for, and still keep all of the family income, which is really good. But I talk a lot about money in this thing, and really the big thing on this is not really the money. For me, the true goals on this is really to enhance your loved one's quality of life during this last time. I'm an elder law attorney, and that's different to me than an estate planning attorney, okay? Estate planning attorney is important. and I do some estate planning stuff. You know, an estate planning attorney's main goal though is to worry about where your stuff goes when you pass away, right? As an elder law attorney, I'm worrying about what your last 10, 15 years of your life are, and the quality of that life, and how you can keep those assets and work them for yourself. Because like I said, I came to this through personal experience, you know, dealing with my mom's Alzheimer's and getting her the care that she needed. And so this is something that I feel passionate about and really important. It also, you know, my mom never, I knew, wanted to be a burden on me or my sister. And so this, us being able to put these kind of things in place to be able to help her out was something that, you know, I knew made her happy, you know, the last 5 or 6 years of her life. She just recently passed away last month, so. And then children want their parents to be cared for, of course, by somebody who's proficient and caring, loving caregiver. I do a whole presentation on caregiving, okay? Caregiving is the most difficult job in the world. I don't know, how many of you have been caregivers? Raise your hand. Yeah, you know, I feel very, very strongly about my caregivers and my family caregivers especially, because you don't know how many clients that I've had where, you know, the daughter's taking care of mom and the daughter ends up passing away beforehand. Yeah. Because they're so busy taking care of somebody else that they don't take care of themselves, right? So I find that that's very, very important. So setting these things up in place, you know, you talk about, well, it's money, you know, it's money and you're just trying to save money or you know, do that for the inheritance. No, it's not really that. It's just making sure that you have this plan in place to be able to get this stuff taken care of so that it makes it easier on those who take care of you so that they can have productive lives as well. And then you always want everybody in the family to have meaningful interactions. Hey, I know my sister is the one who did most of the heavy lifting and taking care of my mom, and I bless her every day for that. But you want to make sure that you have these things in place so that well, this is for me. I want my assets to be able to take care of me when I get old, because I've just seen it so many times when a parent's assets get all used up, the kids are in there, they're starting to help them, and the dynamic almost switches, right? The parents then almost become the child, and the child, you know, and the child becomes the parent, right? And you don't want those interactions to be that way as you get older. You want the interactions to be one of a loving parent-child all the way through as far and as long as you can possibly do. And so putting these kinds of plans in place helps those things get taken care of. So that, you know, for me, by removing these burdens of having all of these legal things in place, it lets the families just spend more time together just being families, right? And so, there's other important documents that you want to make sure that you have in place to make sure that whoever's taking care of you and that your wishes are taken care of. And the main thing about it, one of the main things is what's called a power of attorney. Anybody have theirs in place already? Yeah. Power of attorney is very, very important. And it allows somebody to make financial decisions for you if you're not able to, okay? But there's a little trick with these power of attorneys anymore. And the problem is a lot of people go online or they go to a non-elder law attorney and they get a power of attorney done. And when it comes time to use it, they can't use it because of the banks and the title companies and all of these other organizations now have just tightened up on these things so much. Okay, it's just really incredible. There, you know, California has what they call a California statutory power of attorney, and it's a good power of attorney. You get online, it's 5 pages, it's easy to do, and you just actually initial all of the things that you want your person to be able to do, fill it out, get it notarized, and it's supposed to take care of you. Problem is, no bank in the world will accept that anymore. You know, so my power of attorney as an elder law attorney, yeah, and you can just say it's because I'm an attorney, is 30 pages long.
Yeah.
And I used to work for a Wells Fargo bank, and one of the most satisfying things for me was one of my clients went in there and they were trying to deny them to be able to use this power of attorney, and they just and they said, well, it doesn't have this in it. I said, really? Did you look at page 27, paragraph 4? And they had to accept it. So it's just amazing now how all of these organizations have almost kind of taken over from what, you know, our life and stuff. So you want to make sure that, you know, you have these in place, because the other problem with this power, you know, having a power of attorney and kind of that false sense of security is when you need to use it, you're not able to redo it, right? And then if you can't use it, it's no good, right? So you want to make sure that you have those in there. And you know, because a good power of attorney, you have to have some, you know, specific things on there. You need somebody to help you, you know, get benefits, whether it's a government, you know, through Medi-Cal, VA. I'm a VA certified attorney. And so there's great benefits through the VA you can get if you can outlive the VA, by the way. I'll go into a whole different, that's a whole different thing than a presentation, but allows you to do planning, allows you to get, you know, specific, those Medi-Cal trusts together and stuff. So it's really important that you have a good power of attorney. The other thing now is all your healthcare documents. Those are getting more and more important as we go on. You have your living will and your Hipaa. There's a new forced feeding directive, which I'm pretty excited about. I worked with, I'm a member of the National Academy of Elder Law Attorneys, and we pushed to have this forced feeding directive moved into law here in California so that we can use it. And basically what it says is if you're in stage 6 or 7 of Alzheimer's or dementia, a lot of times your body shuts down. And I saw this with my mom. And so if you're in a facility, they can't let you starve to death, so they force feed you. And they take the spoon, they put the food in your mouth, they hold your mouth closed. It was kind of like my mom making me eat beets. You know, it wasn't very fun and it wasn't nice to see, and she had to do it every day. This forced feeding directive keeps that from happening. So it's nice and helps you keep your dignity. And of course, your final needs instructions. But your living will and your advanced healthcare directives are super important because it allows somebody to make those healthcare decisions for you when you can. You know, you go into the hospital now, the first thing they do, which I always find really amazing, is if you're awake and conscious, they give you a bunch of paperwork, right? You're like, wait a second, I'm sick. The last thing I want to do is sign a bunch of stuff. And you're probably not making the best decisions when you're sick, right? So, you know, to have all of the, you know, they're like, well, who do you want to make your health decisions for you? Well, I guess Joe here on the street who just brought me in would be okay because he's right here, right? And you want to plan this stuff out beforehand, you know, who you want to make those decisions and stuff, and have those directives done for you. It also, a good, well-written healthcare directive will allow somebody to hire and fire, you know, people for you. I've had to do some litigation cases where there was some healthcare workers that were taking care of somebody who probably weren't doing a very good job. In fact, I know they weren't doing a very good job, but we couldn't fire them because we didn't have the verbiage in the directive. You know, they were court ordered, where if we had the right verbiage, we could we'd get that done instead of having to go to court and be costly. Also, you know, lets people authorize, you know, pain relief medicine and the exact specific kind of medicine. Some people, you know, are more tolerant than others on pain, and some people want certain medicines than others, and good healthcare directive will have those in there for you. The big thing is conservatorship. a good trust and a good healthcare directive will protect you from a conservatorship proceeding. And what a conservatorship proceeding is if you don't have any planning in place and something happens to you and decisions have to be made, then someone has to go to court and a conservatorship is started. And so what happens there is the court then appoints somebody who takes care of you, both over your body and helps make those healthcare decisions and over your finances. And so, I love my judges, but, seeing somebody for just, 30 minutes in a courtroom doesn't always make the best impression. And so you may not have the right person that you would want to make decisions for you, on there. I have, the way my trust is set up is I have 2 beautiful daughters and a son. And my son takes care of all my financial stuff in my trust. He's the youngest one, but he's a computer engineer in San Francisco, does really well, knows numbers really well, all of those kinds of things. I would not want him to make a healthcare decision for me, okay? Very numbers orientated, right? I'm already over the curve, right? He'd be saying, oh, well, Dad's had a good run. That stub toe is no good. We'll put him down, right? I have my 2 wonderful daughters take care of those decisions for me because they're a little bit more compassionate and, and know those things. So, that's why I love what I do. Every family dynamic's different, right? You may want different people in your family to take care of different things. So, you want to look at those kinds of things. And then, of course, whether you, what your decisions and what your wishes are. Do you want them to keep you going as long as you possibly can? With modern technology, they can do amazing things, right? With modern medical technology. Or, if you're already in a coma, and you have a heart attack, do you want them just to let you go naturally? And those things, your wishes are done and made in this healthcare directive so that they know. And that's super, super important. I mean, personally in my family, my dad, I was in the Air Force, and this was back in the 80s when I had hair. And my dad passed away. He was younger than I was, but they called me and I flew from Europe back to the US. My mom and dad were divorced. I was the oldest child. My brother and sister were both under 18 at the time. And so he was in a coma and in the hospital. And they said, well, because this is before all the paperwork stuff, right? And they said, well, what do you want? And I said, well, I know my dad. He just wouldn't want to lay there in the vegetable. Let us all go say goodbye and let him go. And so we did. However, my brother, to this day, will say, well, you're the one who killed Dad. Right?
Yeah.
So when you have these things written down, it's not only just for you and your wishes, it also brings peace and things for your family. So you want to make sure those are done, And then you can have your choices of whether you want to be an organ donor or not, and those important decisions as well. Hipaa. The Hipaa Waiver, Healthcare Insurance and Portability Act, that I'm sure all of you have known and heard about that now. Everything is HIPAA, has to be HIPAA compliant, and they're not able to give information to anybody unless you have this document, signed and done. My wife, we had changed doctors, and I went in for I was supposed to go in for a physical, couldn't make it. I asked my wonderful wife if she could, call and cancel my appointment and change it for me. They'd let her cancel it, but they wouldn't let her change it because they didn't have my HIPAA waiver with her signature on file. Something as simple as that. So you want to make sure you have all of those things done and so that the people who you want to take care of you can make those kinds of decisions and stuff. So. It's for us attorneys, these HIPAA waivers are important too. I make sure that my HIPAA waivers are good for 2 years after you pass away. Why? Well, if you're in a car accident and you got hit and you pass away, and they're gonna sue somebody for personal injury stuff, they can't get your medical records unless you have it, so it goes past that. They have to get the court to unseal. So, you know, those kinds of different things, you know, you have to really kind of think about it, so. And then, you know, your living will, we talked about that. Your final disposition instructions, you know, whether you want to be buried, cremated, if you have special religious preferences or special desires. My mom's funeral last month was a beautiful funeral. She was in the Army. She got a full military honors, and that's what she wanted. So it was really nice. She was buried at upstate New York at the Sampson military thing. So she was able to make those decisions of what she wanted and stuff. So it's, you know, it's nice to know all of those things. Elder law, you know, I think I've talked a bit about this. It's not just an old person's problem. One of the things that I really love about what I do is I really can affect the whole family. You know, from helping the caregivers out to, you know, to taking care of, making sure my clients' wishes and desires and hopes are fulfilled through this whole aging process. You know, all of those things is what I really, really, really enjoy about what I do. And the best way to be able to do that is to pre-plan those things and get them in place now sooner than later. And seeing a good elder law attorney to make sure all of those things are in place is key. And there's, you know, quite a few of us in Northern California that you can reach out and touch. There's some great resources to find those. The National Academy of Elder Law Attorneys is one website you can go to, and Elder Council is another. They with good attorneys who know the elder law and the community that you serve, that we serve, to take care of those things. But the biggest trick and the biggest thing and the best advice that I could ever give you is to do stuff sooner than later, because a lot of times later never comes, you know, or when it does, it's a crisis, and it just puts stress on the whole family as well, and makes it more difficult for yourself. I have a few minutes. I can like to answer any questions anybody has.
Right here.
Oh, okay.
I have two questions. We're right in the middle of doing that right now. Within the attorney in our area. We're going to put all of our kids, we have 4, on our health care directive, so that when they call from out of state, and they're all out of state, you can talk to the doctors and find out what's going on if they're not here. But does that type? But I really only want our daughters to make the health care decisions, the 2 oldest ones. But does the HIPAA, if we have all 4 kids on the HIPAA, would that allow them to talk to the doctors, or should we have them both?
So the question was, can you have just certain people on the healthcare directive to make decisions about other people on your HIPAA waiver, so they can all talk to the doctor and be able to participate in those decisions, correct? Yeah, they're 2 separate documents. And I do this oftentimes. You know, even in my own trust, you know, my daughters are the ones who make the decision, but my son can talk to the doctor because he's on my HIPAA waiver. So the people who are on the healthcare directives are the ones who can actually make decisions, but on the HIPAA waiver, you can have, you know, if you want other people to just be able to talk to them so they can, you know, find out about what's going on, you can do that. That's permissible.
Thank you.
Yes, ma'am.
On the bank money situation, you pass away, is the pay on death a good way to handle that?
Yes, so the question was if you can have a paid on death account for your bank accounts. And basically what a paid on death account is a beneficiary of your bank account. If you have somebody on there, if you pass away, you know, that money goes directly to them. For a lot of small estates, that's a good way to go. the way that paid on death account works is it bypasses probate, so you don't have to worry about the probate issues. And it's any money that is in that account goes directly to that individual person. What I don't recommend is that you put your child on your deed of your house. Okay. I've had many clients who do that, saying, well, I'm just going to put them on as a joint tenant on my deed, on my house, and then when I pass away, they get the house, right? So the problem with that is then part of that house becomes theirs, and if they get divorced, it becomes part of their estate, and their future ex will want some of it. Or if they have to file bankruptcy, or if they get in an accident and they get sued, their name's on your deed, and so therefore, you need to that your house becomes part of that asset and can really mess things up for them. Yes, ma'am.
You have a trust made out and you die. Is that just, does that cover the probate part of it? Doesn't go to probate?
Yeah, so the question was, if you have a trust and you pass away, do you have to do probate? Is that correct?
You don't, huh?
Yeah, no, you don't. If you have a trust, you don't have to probate anything, and if everything goes smoothly, you don't even have to ever go to court for that. So it's a really great thing. How many people here have dealt through the probate process? By a show of hands, does anybody have to do the probate process? Yeah, it's something you want to avoid at all costs. Probate's expensive, and it's lengthy, and it's public, and if you can avoid doing probate, it's the best thing you can do. Any other? Oh, ma'am.
We put together a family trust, and we tried to designate everything, and we had a great attorney, and she passed away. So my question is it pretty well set up that we could just go, or do you think that we should, get another attorney to be available in this, if something happens to us?
Yeah, so the question was, she has a trust, and that that attorney passed away?
Yeah.
Yeah. None of us retire, by the way, just so you know. Good attorneys, they don't retire, they just all pass away. But yeah, no, you should revisit your trust at, every 5 years at a minimum to have it looked at. Tax laws change all of the time, and other rules and laws change. Hipaa has been a big thing for just a few years now, and 5 or 6, 7 years ago, you didn't have to worry about those things, so you want to have, that's one of the things a good attorney will tell you is, maybe, you need the Hipaa waiver. But, the estate tax used to be $160,000 not too long ago. Now it's, $20 million for a married couple or more. So some of the things that were done before an older trust really hurt you now tax-wise, so you may want to have it redone.
People need to make sure that they know that you just can't write your will and have it be, you have to go through a trust, or you have to have it done legally. We went through something with a friend of mine that died that has been horrendous, because they were ready to sign, people were ready to sign for the house, and the title company realized that the person she had designated as executor had never been approved. There's no legal thing. So you need to have all of that approved when you die as a mess.
Yeah, no, yeah, she was giving us an example of how a friend of hers, they hand wrote a will, which is called a holographic will. Is that what it was? Yeah. And, though legal in California can often end up causing a lot of issues for families and problems down the road. Yes, sir.
My wife has been in a nursing home for over a year now with Alzheimer's and Parkinson's, and we don't have any children. But a few months ago, I got the living trust, well, she wasn't even able to sign her name on it, so they put it in my name only. And we have her nephew, everything listed on it, but I haven't had anything notarized yet. I've been putting off doing that. And I had a nightmare with the Medi-Cal people. I had to requalify her, spending down. It was just a horrible nightmare, and I'm kind of in limbo. What should I do next?
I would recommend that you see an elder law attorney in your area. That's what we specialize in. There may be ways to protect and shelter some of the assets you have. There's a couple things that you really need to worry about when you're talking about Medi-Cal and getting assistance for nursing homes, or if you have somebody in a nursing home. First of all is qualification, getting them qualified for it. But the other thing is what they call collection, which after the person's been in a nursing home, the state can come and collect what they spent on that individual through their estate if you haven't set up a proper trust, or if you have to probate something nowadays. So there's all sorts of different aspects you kind of have to look at. One of my first mentors when I came into law told me that law was like a crystal ball. You can't just see on the outside, you have to kind of look all the way through, because there's all these different layers. And so just answering your question, I couldn't give you direct answers. We'd have to kind of sit down and see what your specific situation would be on that.
Question?
Oh.
Another question? You mentioned beneficiaries on your paid on gift, that in the account we have, which have beneficiaries. How does the trust fit in with that? Because we thought we could put everything into the trust.
If you have a beneficiary who's has paid on death on your accounts, that will go before it goes into the trust. If you want the money to go into the trust, if you have a trust, you have to make the trust the beneficiary.
Okay, and then what we just found out recently though, talking to several people, that really we need to have an account set aside for our two daughters, because they would be, if anything happens to us, they would be coming in, they don't have any money to pay for anything. So keep a separate cash, CD or something, money market in a different account, so that they can have access to that for their needs to take care of us.
For the final expenses, that type of thing, yeah. If you have a trust, you can fairly quickly get access to it if they're the successor trustee. They just go in with the death certificate and a copy of the trust that shows that they're the successor trustee, and the bank at that time should. But you have the issues of, you have to go when the bank is open, get down there and all of that kind of stuff. Some people I know do keep a few $1,000s in a certain, account with just them on there. If the trust is done right and everything, then they should be able to access it even through the trust pretty quick. Young lady in the book.
With the family trust, how careful do you have to be to put everything in it? We have some individual stocks that are just in a safety deposit box. How does that work? Is that a problem? Or?
So the question was, how careful do you have to be to get everything in a trust? Trust is only as good as the things that you have in it. If the trust is well written and there's provisions in there that say, all my items are, that I want all my items in the trust, an attorney can do what's called a Hagstad petition and get those items that weren't listed specifically in the trust moved over to the trust. When I do my trust, I have particular documents. I'm a car guy. I love cars. I buy and sell cars all of the time. It's a horrible hobby, my wife says. But if I had to go to the DMV every time I had to change a title, I'd spend my life at the DMV. So I have documents that I do for my trust that just basically says that, anything that's not in the trust, personal items, stocks, those kinds of things, especially if they're loose leaf certificate stocks, I meant for them to be in my trust, and that will work as well. So, okay. Anything? Thank you.